Hello and welcome to Estate and Probate Management. In this module, we shall be discussing the introduction to estate and probate management, which is a professional approach to orderly wealth transition. The module content that we should be looking at in this module include meaning and scope of estate and probate, as well as key terminologies, historical evolution and importance in modern society, types of property and common myths, as well as realities for beginners. We'll also look at the overview of estate life cycle. We'll now look at the legal framework in Nigeria, that is the will, customary law, Islamic law, and probate registry, before we now draw our conclusion. Let us begin with the introduction. Why estate management matters? Death is inevitable, but disorder is preventable. When a person dies, their legal existence continues in the form of their estate. Without proper management, this transition can lead to financial hardship for the families, prolonged litigation in the court, permanent breakdown of family relationship. Therefore, estate and probate management is a legal process, a financial management function, a conflict prevention mechanism, a wealth preservation strategy, and a specialized professional career. Let us look at the core concept, that is estate versus probate. Estate is the what, while probate is the how. So estate is the total property, that is your asset and liability owned by a person at a time of death. Whereas probate is that is the court supervised legal process of validating a will and authorizing an executor. Estate include everything such as land, bank account, debt, even digital assets. Whereas probate confirm the will is authentic and grant authority to administer the estate. Estate exists immediately upon death, whereas probate occur after the death through a court process. Having known that, let us look at key terminologies that you must know in estate and probate management. Number one terminology is the decedent, that descendant, that is the deceased person, that's the person who died. Then we have testator, or that is, or testatrix, which is a person who made the will, testate. Then intestate is a person who died without a will. Executor is a person appointed in the will to administer the estate. Administrator, on the other hand, is a person appointed by the court when there is no will. Then beneficiary or heir is a person entitled to inherit the estate. Then grant of probate or letter of administration is official court document granting authority. So these are some of the key terminologies in estate and probate management. Having known that, let us look at the historical overview of estate and probate management, how we got here. The evolution of successful law in Nigeria. Number one, estate and probate management emanated from ancient and customary roots, that is communal landholding, inheritance guided by family head and tradition. Then another history is English common law. It introduced formal written wills and the concept of probate through colonial influence. So the history can be traced through the colonial area in which English common law was introduced. Now we have another historical antecedent, which is statutory law, which includes codification of laws, that is the Will Act of 1837, which creates a formal legal system. Then the modern Nigeria is a unique plural legal system where statutory, customary, and Islamic law coexist. So the Nigerian society is a plural legal system where statutory, customary, and Islamic law exist side by side. Having known that, let us look at types of property in estate and probate management. That is what constitutes an estate. Now we have number one, real property, which is otherwise known as real estate, which includes land, building, farms, and anything permanently attached to them. Then we have personal property, which is movable asset, which can be subdivided into tangible property like vehicle, jewelries, furniture, and livestock. Then we have intangible that cannot be seen, which include bank accounts, share, pension, intellectual property, and cryptocurrencies. Now we have special categories of properties, estate, which include jointly owned property, uh, which may pass directly to the survivor. We have trust property managed separately by the trustee. Then we have business interests shared in company partnership. So these are the special typology of estate. Now let us look at the common mind versus realities. The mind here include only land and building form an estate, but in reality, all asset and liability forms part of an estate. Another mind is that a verbal gift of property is binding after death, but the reality is that most property transfers required written document. Then another mind is that family members automatically inherit without paperwork, but in reality, legal documentation and probate may be required. Another mind is that digital assets like crypto, online account are not part of estate, but in reality, they form part of estate if assets can be established. Then another mind is that a will prevent probate, but in reality, a will guide the probate process. It does not avoid it. Having known that, let us look at the overview of estate life cycle. That is a journey from death to distribution. Now, immediately after death, secure the asset, locate the will, and notify the parties. Then number two, information gathering, identify, value, and invent all assets. Then administration, obtain grant of probate or letter of administration. Then pay your debt, pay the debt and taxes. Then distribution, you now transfer remaining assets to the beneficiaries. Then finalization is close the estate, obtain legal release. Then the timeline is usually 9 months to 3 years. So these are the overview of life cycle of estate and probate management immediately after death. Having known that, let us look at challenges in estate life cycle. The challenges, common hurdles in Nigeria include court blockage, which include delay at the probate register can extend the process. Then family dispute is another challenges in estate and estate management, which contest and disagreement among beneficiaries. So it's a challenge. Then we have another challenge, complex access, properties or business in multiple states and countries requiring additional steps. Then we have dying intestate, no will. That is when somebody dies without a will, it creates uncertainty and applies rigid statutory and customary rules. Another challenge is invalid wills. Failure to meet strict legal requirements may lead to litigations. Then we have cultural pressure, which is balancing legal right with tradition and traditional expectations of the people. So these are some of the challenges in estate and probate management. Having known that, let us look at Nigerian's plural legal framework. That is navigating multiple system of law in Nigeria. Nigeria's succession law is not uniform. It is a combination of one, statutory law, which that governs when a valid written will exists based on the Will Act and state laws. Then we have customary law, which is unwritten tradition of various communities, which applies based on disease personal law and must not be repugnant to the natural justice. So the customary law must not go against the natural justice. Otherwise, it will be declared null and void. Then we have Islamic law, which is Sharia law that applies to Muslims. Some of the features which features fixed fractional share to her. So one of the features of Islamic law is that a certain fraction will be given to the what inheritance. That which limit will of 1 to 3 of the estate. So these are some of the law that guide estate and probate management in Nigeria. Having known that, let us look at the role of probate registry. That is the court's central function. The probate registry is a division of the High Court that is responsible for the following: one, validating will; two, issuing grant of probate, that is when there is a will; three, issuing letter of administration when there is no will. Then number four function is accessing and collecting probate fees. Then number five, the last, registering all estate related documents. Without authorization from the probate registry, Titles assets cannot be legally transferred. Now let us look at how the legal system interacts. That is a practical overview. Now we have the legal system. One, statutory law, uh, 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 where when it applies is when there is a will. Then the key features is testimony freedom. Then we have customary law, which is applicable to personal law and is normally applied when there is no will. The key feature is that it is traditional succession rules. Then we have Islamic law, that applies to Muslim estate and choosing application. Key features is that a fixed fraction inheritance is being given to the beneficiary. Then we have probate law, which applies court supervision of all estate. The key features is that it involves legal authorization process. In practice, a valid statutory will usually overrides customary succession, but probate authority is required regardless of the system applied. In conclusion, that is the model summary as well as the key takeaway. The foundation is now laid. An estate is the sum total of a person's assets and liability at the time of death. A probate is the legal process that gives authority to manage and distribute that estate. Nigeria's legal landscape is pluralistic in nature, requiring knowledge of statutory, customary, and Islamic law. Understanding property types and the estate life cycle is essential to avoid common pitfalls and disputes. Estate and probate management is not just about sharing property, but it is about safeguarding rights, ensuring compliance, and preserving generational wealth. Thank you, and God bless you.